loveys and Mr. Bederow.
How are you?
It is, what is today? The 24th, Tuesday, June 24th, 2025. And on this summer school edition of Nurse Kim and Mr. Bederow, we're going to talk all the shit about post-trial media coverage and some incredible new statements and interviews that came out last night and today. How are you, Mr. Bederow?
I'm good. How are you?
Wonderful. Wonderful that I'm here with you and that we are like, we're hot. We're colorful right now. And we got color. I got some outside because it's hot as heck. It's hot as Hades out there.
Yeah, no, and it's usually like 2 or 3 to 4 degrees hotter here than it is up there. And it's just so freaking hot. My God. Yeah.
I know. Thank gosh for central air conditioning, and to our friends that do not have it, keep those window AC units. And I feel bad. I get nervous for the elderly, and I always want to get them an air conditioner if they don't have one, because they still think that they can just use a fan, and it's not good.
Well, blowing the 200-degree heat isn't going to help. So.
Absolutely. Yeah. I know, the good old, but it feels like, listen, back in the olden days, we used to get like a couple of 90 degrees. You'd get your heat wave, right? If it was 3 days over 90 degrees in like August. Now we're getting this in June.
I don't know about you, but here it's humid because we had heavy rain before. And, when I spent my years in Arizona, it would be 110 degrees, but dry. Much more comfortable than it is here when it's like 94 and hot and humid.
Yeah, it's the worst.
Yeah.
But you've been busy. I saw you the other night. I saw you with Turtle Boy and juror number 11. Tell me everything. What'd you think?
I find her and the foreman today, who I saw at some point, I saw his interview. They disabused these troll theories online about corruption, nullification. Every juror who's spoken has simply said what you would want any juror on any case in any state at any time to say, which is, we followed the law, we deliberated, we considered, we recognized the burden of proof, we recognized the task we were charged with, and the evidence didn't support it. Now, they may be triggered because the two most prominent jurors, meaning who have spoken out the most, have both said, I think she's innocent, not just not guilty, which legally there's no difference. It doesn't matter. You either get
in the eyes of the law. Yeah.
You don't, right. But I think these people are upset because both of those jurors had such a profound understanding of the task that they were to do. They did it. It's great to see. It's very validating for a lawyer to see that jurors can follow the law, even in a case like this, where you're just predisposed to believe there's going to be shenanigans afoot.
Yeah. Yeah. I feel as though it was so impressive, Mr. Bederow, to hear all of the jurors, juror 11, the other juror, to hear the foreman and another woman as well. We heard a female, I can't remember her number. Maybe she was number 4. Pardon me, guys. Wow. But like you said, it was that deep understanding of exactly the task put in front of them and the compassion for the O'Keefe family, in which I believe they showed, saying, I can't begin to imagine what the O'Keefe family as a mother, a father, a brother, that they're experiencing. But they had to do what our law, demands of them to do. And they took it so seriously. It's restorative to your faith in the judicial system, in my opinion, and in the jury system.
It is. But the crazy thing is it happens every day. And the fact that on this case, you have to feel that way and almost against your better judgment, where you just assume the worst, that they know what they're talking about, is very validating when it shouldn't be. And, you've seen what's going on with some of the jurors. I haven't seen much harassment of the foreperson, and I wonder why. I wonder why that is.
Because he's my guy. Okay. I said that from the day I went in there, and I just knew that he was like, I didn't care that he didn't take notes. I knew he was a vibes guy. I knew that he had an elephant memory. And I think that you're implying that it's because, you wouldn't want to muff with him. But
No, I'm implying that the trolls are sexist, actually. That I think it's much easier to go after a very opinionated,
woman,
strong, principled woman who wasn't taking any shit, as you saw. Whereas this guy, he's not as out there as she is, but doesn't appear to be beginning of that DePetro abuse, any of the other, wacky lunatics abuse. And I don't know, but I look at them and say, what's the difference here? And the big one that comes out is gender. And I'm not a feminist. I'm not one of those, but there's been so much abuse to one particular juror for having an opinion and sharing it. And for the crime of what? Getting called by the media and being willing to speak.
right?
It's just interesting to me.
I totally agree. And I did want to say about juror number 11 specifically, I kind of held my tongue online because, I'm not trying to get in the weeds with it too much. I don't want to stoke fires in any way that I don't have to. But when certain people, including a former FBI agent, attorney, Mr. Mark Bederow, decided that they were going to doctor a soundbite that made it appear as if juror 11 stated that she was in the deliberation room during deliberations and was following all the journalists in the room, I damn near lost my mind. And it was disgusting and disgraceful. And she then shortly after took it down.
Where do you even begin with that? To me, you begin with it. That was so obviously not true. I mean, think about what that video, which was created by some loser, incel troll, right?
Right.
So put that aside. But this is a trained investigator, we are told, from the FBI. This is a serious former criminal investigator who sees a video like that and runs with it because she thinks it's actually, oh yeah, that makes sense. How stupid do you have to be as a trained FBI investigator to think that the juror is giving an interview saying, oh yeah, I was in the jury room and I went to Twitter and I just decided to look at all the, Karen Reed orders to get advice from the deliberations. She ran with that. So I think the real lead of the story is how profoundly stupid Coffindaffer is. And that's the lead. The second story is what a scumbag the other troll is to even create that video, which is just disingenuous. It's defamatory. It is. That's absolutely defamatory. And if you're watching Troll, be aware of that. That's totally defamatory. But Coffindaffer thought, as a trained FBI agent, that was, I'm going to go with that. And I don't even know what you can say about her anymore. Just how the amount of ignorance that
required
her veins is just insane.
Yeah. And then her spin on it after I called her out and said, absolutely, how dare you, not fact check it. And in a video that was not of the best quality either, but completely egregious behavior that you're accusatory of here. She doesn't check anything. And then I said to her, after the hoopla that was made after trial number 1, let's turn back the hands of time, Mr. Bederow. We know damn right well that both what I would call the anti-Karen Reed and, the Karen Reed is innocent or Karen Reed is guilty communities Nobody believed that jurors should be subject to targeted harassment, right? And intimidation. And yet they actually went as far as Judge Cannoni impounding their names, right? For into perpetuity and forever, because there was a fear of some sort of retaliation. Okay. Now, this anti-collective group has gone they've done a complete 180, and now it's fair game. They are criticizing, they're chopping up her words, putting horrific lies out onto the internet, accusing her of her bias, of being, an plant, also body shaming her, okay? Saying that she doesn't look like what she looks like in her picture. How dare you, you friggin' pigs. I want to just, I can't. That enrages me. And these are all the same people who are telling us that, the justice, everything needs to be in court, and how dare anyone on the Karen Reed side have an opinion about a police officer, including Michael Proctor or Buchanan, but they're doing this to the jurors. It is disgusting, in my opinion.
Well, I mean, if we're going to do this in Massachusetts and they have a statute, the famous witness intimidation statute, right? 268, section 13B, that they all like to wave around and use, they need to use it fairly. Okay. And if you're going to use it against journalists for, bothering people, then you need to be fair and equally apply the law. And if you look at the text of the statute as it relates to jurors, what these people are doing is open and shut in violation of the statute, which simply says if you retaliate against a juror because of their service by harassing, intimidating, or threatening, then you're guilty under the statute. You said the body shaming, which again is sexist, I think, primarily. Yeah. I've seen reference to children.
Yes.
Reference to hoping you're dead. I've seen reference to the police are coming. I've seen reference to subpoenas. I've seen reference to you're corrupt. I've seen reference to you must have been paid off. We could go on. And if you're going to sit there and tell me that, oh, who are you? Because you represent, the blogger, you're missing the point. Do you or do you not believe that this is harassment? Because if it's harassment for one, then it has to be harassment for two. And nobody in the criminal justice system should be more sacrosanct and off limits than a juror who is hauled in there, no involvement, does their civic duty, renders a verdict in accordance with the evidence, and then wants to go home. That's it. That's it. And, if the jury had reached a verdict in the other direction, and if jurors were being harassed to the level that they were, which I'm not sure would happen, by the way, I don't think it would. But if it did, what would this clown DePetro be saying should happen in that situation, as opposed to what he's doing? What would this idiot ex-FBI agent say as opposed to what's be doing? What would wacky Wendy Murphy be saying
Wendy,
as opposed to calling for the, taking away their citizenship rights and whatnot? I mean, there is a lunatic fringe that has followed this case for so much time, and they just can't accept what most reasonable and sensible people have known was inevitable to happen, which was there's just reasonable doubt. And, it happens every day in America, all over the country. Juries deliberate. They look at the evidence. They evaluate it. They reach a verdict. They sometimes, not as often as guilty, but they sometimes find not guilty. And then they go home and it's over. And that's it. By the way, even in highly contentious cases, there's plenty of highly contentious murder cases, sexual assault cases, all kinds of things. And the jury still goes home and then they're done. And in this case, you see what's going on. And it's the keyboard warriors. It's awful. But, some of them have maybe not the most sophisticated or important platforms in the world, but like the ex FBI agent, this DePetro clown, some of these other ones, they do have some degree of a platform, and they're dangerous. I mean, they are instigating danger.
That's it.
And let's be very clear. If you're going to follow the letter of the law of the Massachusetts statute, they are committing crimes. And if that bothers you and you don't think they're committing crimes, then check yourself, and maybe some other people shouldn't be facing crimes either. If you think this is fair, just be fair, be consistent, equal application of law. But they'll all fade away. They'll move on to the next one at some point. But their obsession right now with harassing jurors, one in particular, it is insane and something I've never seen, and I assume I'll never see again. And I just assume it's a byproduct of the attendant mental illness that has just befallen so many of these people who have nothing better to do than root for a certain outcome of a criminal case. And then when it doesn't go their way, they demand subpoenas, investigations, arrests. And these people, you should pity these people. You really should. I mean, imagine being so beholden to government that your first reaction is, the jury didn't do what I wanted, so you should seize all their phones, arrest them, and investigate them.
Yeah.
Can you imagine being such a loser and so beholden to state power and authority that your first reaction is go after the jurors and seize their phones and arrest everyone, investigate, subpoena? I mean, they just support tyranny. It's sad.
Yeah. Yeah, and I think that realistically, there is call 988 if you need help for mental health and illnesses in the Commonwealth and beyond, because this has really been a transformative but a toxic trial to the point. Oh, it's not. It's so not healthy, Mr. Bederow. And I am one that really enjoys. I want to always talk to both sides, right? I want to have an opinion. I want to be able to see where is it that we can find a fundamental foundation here. And then we can disagree, but we don't have to go to hell every single interaction.
I mean, there are so many hangers on and meaningless people in this whole process who are so into this and insert themselves into this. I mean, can you explain to me why some random housewife in Indiana who sits on the couch is so obsessed with all the arrests and defamation lawsuits, and you're going to get this, and gets interviewed by some of these wackadoos with their, minor platforms? Why would anybody on a couch in Indiana be so obsessed with a admittedly interesting murder case in Massachusetts, but to which you have no involvement? I mean, you're upset with the result. I get it. But why are you, assigned as the lieutenant of you were assigned by the marshal of the Supreme Court of the Island of the Misfit Toys to round up people and do this? I mean, what is wrong with you?
Yeah, I think there's a lot, right?
One example, by the way, there's plenty of these people. They have no attachment. It's a murder case where they feel great sympathy for the deceased, which I think most people would.
Yes.
Jury decided there's reasonable doubt, as most people agree with, by the way.
Uh-huh.
And you are on a crusade of subpoena, arrest, indict, and sue everyone.
Yeah.
What is that? Why?
Yeah, and it's so nonsensical, like you're saying, and it's just, I'll see people post from the redhead on the couch in Indiana, and every time there is an opinion, Mr. Bederow, about the case. I mean, this isn't attacking anyone. If you say Hank Brennan, A, B, C, or D, she's like, be prepared. Okay, be prepared. You're getting served. And I'm just like, ma'am, step away from Twitter. You need to go touch grass.
Served by who? For what?
I don't know. Al Bundy, her husband, the
hearing?
shoe salesman.
I mean, this is just, again, these people, something is seriously off with them, and it is what it is. But, you know, they're not worth that much attention.
No.
And sometimes it's worth a laugh because, you know, everybody's catching a lawsuit for having an opinion about everything. But, you know, and again, they, you know, they all tend to gravitate towards each other. It's a small echo chamber, and eventually they'll disappear and find the next thing to complain about. When, you know, what they really ought to do is step away from the computer, you know, have a nice dinner, have a nice meal, enjoy your family.
Yeah.
Just do something productive, you know. Screaming on your keyboard from halfway across the country about what's happening in Dedham, Massachusetts is bizarre when you have no skin in the game. It's just weird.
Yeah, I've never really quite understood that either. And I did, the only thing that I wanted to end on just regarding that is that I tried to come out specifically afterwards and be aware that there would be a small segment of people that were like upset, and you're allowed to be upset. I can empathize with your upset. I can empathize with any of your opinions about like this sucks, or being even opinionated about, you know, I don't like that this juror says this. Go for it. But
That's
once
fine.
you start crossing that line, it is disrespectful, in my opinion, to Officer John O'Keefe, to his family. Like, you all look really, really unhinged. And, you know, so I tried to tread lightly, and then I had to nuke because I was like, nope, we're not going to do this. But kudos to juror number 11 for, when I tell you the amount of absolute garbage that has been thrown in her lap, and her rebuttals and responses, and keeping it classy, because you contend I have a time or two not been classy in the response, right? I called somebody a gutter trollop, and it was actually the one who lives in Indiana. And, you know, these are things that you don't want to say. You don't want to say that to somebody, but, you know, then I told her to eat shit and bark at the moon. But these are things that, you know, get away from me. Leave me alone. And I just wanted to say to juror number 11, you know, God bless you. Tiny Mary and Tiny Jesus are with you, because you have really faced it all in stride and have gotten your message out, and the message of the 11 other individuals. This wasn't juror 11's. She was not wielding a power and the choice here. 11 others, 12 total, freed Karen Reed.
So,
and that's it.
Let me just add one last point, and then you can move away from the jury. The people who are complaining about the corruption, the this, the that, they deliberated for 4 days. They sent multiple notes to the court. They never indicated that they were deadlocked. And they acquitted on charges and convicted on a charge. What more do you want about a jury who takes their responsibility seriously, deliberated consciously? You heard the media interviews of some of them. Move on. It's over. Okay, the jury did what the jury did. It's very rational. It's very reasonable. There's no corruption. There's no nullification. It is what it is. They didn't find her guilty because there's reasonable doubt, which, by the way, is correct.
Oh.
So just move on.
Yeah, absolutely. And Mr. Bederow, just for anybody who is unaware of what jury nullification means, can you explain to our best friends from out of town and why that was even brought up by some of these trolls?
Well, it's brought up as an excuse to say, oh, you know, the evidence is overwhelming that she was guilty. I mean, jury nullification is just a concept when a jury, or certain jurors anyway, decide to vote not guilty for reasons other than finding reasonable doubt. They just nullify the law. they go rogue and do what they want because there's no way to stop them. Usually, if you see nullification, it would happen for a reason. Incredible sympathy to the defendant that they're wrongfully being persecuted, albeit they might be guilty. Sometimes you see it as an act of civil disobedience. You know, someone could be charged with a crime that is political in nature, and they just say, I'm not doing it. It does happen. It's not that common, but it's a thing. It's real. But there's no evidence that that happened here. There was a ton of reasonable doubt. And every single juror who has spoken, and I think at this point it's been like 3 or 4, even 5.
4, yeah. Well, I've seen 4. I don't know.
There was reasonable doubt, and that's why we did it. So this was not nullification. You know, listening to a few online trolls who attend or graduated from the Twitter law school about telling you why it was nullification or why there's no reasonable doubt. Nobody cares in the real world that Kate Peters says Karen Reed is guilty. Okay. I mean, nobody cares that the woman from Indiana says the verdict was wrong. Nobody cares that some, you know, lunatic radio host in Rhode Island says that, you know, there was guilt beyond a reasonable doubt. Cares. Nobody cares what Julie Grant says about any of this. What matters are what the 12 people that were in the box and in the deliberating room decided, and they decided unanimously, to the surprise of no one, or at least not most rational people, that there was reasonable doubt. So we're done here. It's over. Find something else.
It's over. Yes. And after Juror 11 had come forward, also the other male juror and another female juror, before today, when we heard for the first time from the foreman, we got a statement yesterday from Hank Brennan. And this statement was exclusively aired on the one, the only Julie Grant of Court TV. Okay. She was ready. She was willing and able to breathy say this statement. And I'm going to read it in a Nurse Kim voice versus a Julie Grant voice. Okay. Clutch your pearls, clench your butts, loveys. A statement from Hank Brennan regarding the Commonwealth v. Karen Reed verdict. I am disappointed in the verdict and the fact that we could not achieve justice for John O'Keefe and his family. The district attorney, Michael Morrissey, appointed me, giving me full discretion to independently assess the case and follow the evidence, no matter where it led. After an independent and thorough review of all the evidence, I concluded that the evidence led to one person and only one person. Neither the closed federal investigation nor my independent review led me to identify any other possible suspect or person responsible for the death of John O'Keefe. The campaign of intimidation and abuse that has been waged, funded, and promoted in public and social media is the antithesis of justice. This type of conduct becomes commonplace. If this conduct becomes commonplace, it will threaten the integrity of our judicial system, affecting both victims and the criminally accused. We cannot condone witness abuse, causing participants to worry that their own safety or that of their families. It is my hope with the verdict, the witnesses and their families will be left alone. The harassment of these innocent victims and family members is deplorable and should never happen again in this Commonwealth. My heartfelt condolences to the O'Keefe family and faith that over the coming years, they will find peace and closure. Hank Brennan. How about some thoughts on that, Mr. Bederow?
Disgraceful, shameful, unethical, and petty. That's not what a prosecutor says when you lose a jury trial, okay? A prosecutor says when they lose a jury trial, I'm disappointed in the verdict. That's fair. I respect the jury's decision, although I don't agree with it. That's fair. I'm disappointed that in my view, I couldn't get justice for the O'Keefe family. That's
Totally.
And you know what? After you say that, sit down and shut up. Okay? Because when you devolve into, I review the evidence, one person, let's be very clear. Let's not mince words. That's unethical. You lost. Okay? The murder case is over. The manslaughter case is over. The leaving the scene of an accident in a homicide case is over. You have no right whatsoever to comment and accuse an innocent defendant, an acquitted defendant found not guilty, to say, yeah, but she's guilty. Okay? That is unethical, what he said. It's disgraceful. And then to devolve into, well, really, it's all Turtle Boy's fault, which is what he said without saying. And I responded to that, actually, on that point to Fox News yesterday, because that was also disgraceful. That was an attempt to put the blame for your own crappy case elsewhere, and at the same time to soil a potential jury pool for another defendant who is presumed innocent. Okay. And you're a criminal defense attorney and you know that. Okay. So let's cut the crap with the woe is me statements. She's guilty and it's all because of the witness intimidation and it's not right. Okay. That statement was shameful. It was unethical, and blaming another defendant that you're obsessed with and that the DA's office is obsessed with is improper and should never happen. You should never hear a prosecutor who loses say anything other than I'm disappointed, but I thank the jury for their service. By the way, which is what Morrissey did, okay? Let's be fair. I'm no fan of Michael Morrissey, but his statement was, you know, the jury spoke and it is what it is.
Finally, yeah.
But fair is fair. That was an appropriate statement. Brennan's was 95% entirely inappropriate, whining, unethical, sour grapes, petty, and still to this day seems to be offered in service of certain people that he considers witnesses who he never called, mostly, by the way, in defending them. And I have to tell you something. When he says and blames what he perceives to be criminal witness intimidation as the reason why he lost and how it affected the outcome of this case, let's be very clear. You didn't call these people, but you know what they did? They all went on TV. Okay?
Yeah, they did.
Proctor went on TV. Both McCabe's went on TV. Brian, Nicole, and Chris Albert went on TV. Now, I don't blame them for that. It's their right. It wasn't aired till after the trial, but they had no problem doing that. But you chose not to call them as witnesses. So spare me, you know, the faux righteous indignation of this is why we couldn't get a fair trial. And this is all, you know, Karen Reed's fault, her scummy lawyer's fault, Turtle Boy's fault. It's everyone's fault. No, the reason you lost, okay, the reason you lost is because every single medical expert who was called to testify in this case said there's no evidence of a collision. There's no evidence which would support that, both medically and from an engineering standpoint. Okay? That's why you lost. Okay? You lost because you were so desperate to find any expert you could that you hired Aperture, which was just an embarrassment to that accident reconstruction community, if that's a thing. I don't know if that's the right term.
Oh, no, they have a community. Oh, they have, absolutely.
That's why you lost, okay? You lost because you chose a finger painter for $400,000 to lean into a car who based his data on an academic fraud who doesn't know the difference between bits and bytes, what day of the week it is, and then changes his opinion mid-trial. That's why you lost.
Yeah.
So to give that statement and then tamper with a jury pool on a future case is disgraceful. And, you know, I said some of that to Fox News yesterday, and I'm fully aware of what Alan said today. And God bless him, because he was directly on point and hit the bullseye.
Sure did. Now, with that being said, just I wanted to hit my points on the statement from Brennan, right? Was I I found it every single thing that you said. Of course, you are incredible. You articulate it better than me. But I wanted to say when he said the evidence, I went over all the evidence and I concluded this. That I was like, "Oh, really?" Like the evidence, for example, the hoodie that you made a material misrepresentation to the court over when you allege that holes could have been made on January 29th, 2022, but they were actually done by your own criminalist in May of 2023. Oh, the evidence like the taillight pieces that were found by Trooper Michael Proctor at the time, former disgraced trooper, that you didn't even enter into evidence because you didn't want it to be, because you didn't want to address any problems for your case. You were hiding the ball the entire time. And in my opinion, his review of the evidence was never complete. Hank Brennan never completed his summer reading. He never knew this case like half of the people of the Commonwealth, like us, all right, like our loveys. We knew the case. In my just saying with the evidence and things that he would get up and his misrepresentation of the defense team, him getting a TUI dump from the FBI when it really came in discovery from Liza Little about the payment that was made to ARCA. He is an absolute shitbag. And I respectfully that you would have the canyons. You are not the judge and jury, okay, Mr. Hank Brennan. And if the investigation, which was alleged and which was believed and is true, that it was done as a sham the entire time, day one, you had tunnel vision, or the Mass State Police did rather, and they did anything they could to pin it on the girl, then where in the hell do you think you were going to review something that was going to take you down a different path?
Look, his statement was, as I said to Fox News, in substantial part inappropriate. What that means in English is it was about 95% unethical. But of all the terrible things that he said, the one part that is entirely unethical, okay, and you have to understand how disgusting this is. The jury acquitted Karen Reed. The case is over to her benefit, okay? She's not guilty. You are a criminal defense lawyer, mostly. You're a prosecutor, which makes it worse in this case. You have respect for the jury system. Sometimes you win, sometimes you lose. The jury determines. Okay. The one thing that is verboten that you never do, the third rail, if you will, in how this system works when you're a part of it at a high level is you don't blame the jury. Okay. And the last thing you do is then say, oh, but by the way, I investigated and I determined she's guilty. Honestly, go fuck yourself, sir. You don't say that. Okay. You don't lose a trial where a jury acquits someone and finds overwhelmingly not guilty and say, I gave my sincere obligation to look into this, and I'm telling you all I saw when she's guilty. Again, respectfully, go fuck yourself.
Look, we could find something in our pocket for him.
You don't say that. You never, ever say that as a prosecutor. Okay? You can think it privately. I get it. But to do that as a prosecutor, shame on you. You never do that. And I think back to the days, when I was a prosecutor in Manhattan, the DA is a legendary guy, Robert Morgenthau. He was, even 100 years, it felt like old back then. Now they won most of, there are a lot of big high profile cases in Manhattan, as you can imagine. And in a place like Manhattan, they win a lot more than they lose. But every now and then you come in second. Okay. And a lot of those times you sit there, you scratch your head and say, how'd that happen? That shouldn't happen. But you know what? You would never see a professional, respectable prosecutor ever say she was guilty. And, I don't care what the jury said. And I have to tell you something. It's bad enough if you want to bitch and moan about the witness intimidation because you're obsessed with Turtle Boy. Okay.
Mhm.
You tried to use it in the trial. You tried to kick him out of the courtroom. You tried to come after Lucky Lawfer, and you did everything you could, and it didn't work. And then when you lost, you bitched and moaned about it. But, you know, I'd give you a shred of respect if you did the following. You said at the same time, leave the jury alone.
Oh.
And you didn't do that.
No.
Why not?
Because he co-signed it. Right? Fill in the blanks, babes. Fill in the blanks. But like, I love the passion, though, Mr. Bederow, that you are able to say, though. No, really, though, but it's passion because you're saying that's not right.
Maybe the language was too strong, and if it was, I apologize. But the point is this.
Don't apologize.
Take the cuss words out of it, whatever. The point is this. You never, ever, as a prosecutor, lose a murder trial and say, I investigated and I'm telling you she's guilty. Okay. And I'm telling you, I would have won if it wasn't for this witness intimidation, which just happens to be, by the way, the obsession of the DA's office prosecuting someone else that you're blaming. That statement he made is so gross. It's so odious and so emblematic of why nobody, no reasonable person anyway, feels that the Norfolk DA's office is in this to do it fairly, responsibly, and ethically. And, you know, and that's similar to what some of the comments that you saw Alan make too, that they were just obsessed with at all costs, get Karen. And I mean, I've said this to you before. It's like Moby Dick. Morrissey is like Captain Ahab with the harpoon, trying to, you know, throw the harpoon into Moby Dick, who's Karen Reed. And it's pathetic.
Yeah. And like, that brings me to another point, not even with Karen, but saying the witness intimidation is a direct shot, like you said, of Aiden Turtleboy Carney. Now,
that's all by design. Absolutely. That is trying to tamper with the jury pool. Look, we're going to have 3 trials coming up over the next year or whatever, okay, on those cases. There are literally going to be 3 trials. 2 of the 3 are essentially, well, they're all witness intimidation trials, but, you know, one of them relates to the witnesses, and 2 of them relate directly to the witnesses or not witnesses, you know, prospective witnesses in this case. I'm sure those people are on the witness list just so they could be deemed witnesses, and he was never intending to call them. I don't even care about that. But to make those comments about that as part of your statement on an acquittal, that's looking ahead on behalf of his constituents, Michael Morrissey and the alleged witnesses that he speaks for, to do them a solid. Okay. And you saw Michael Morrissey do the same thing 2 years ago when he gave his hostage video. That was on behalf of the same people.
Oh,
it's like they're making statements and doing things on behalf of private citizens. And that's not how a DA's office is supposed to operate. They represent the people, the Commonwealth. We're in Massachusetts. They represent the Commonwealth as a whole, not individuals within it. But you start to wonder and say, why are they so bent on pleasing certain people?
Get bent. Yeah.
Job.
Yeah. But I feel like there should be a retraction of that statement. And why I say that is, well, is he allowed to say witness intimidation when it's alleged? Okay. Someone hasn't gone to a trial for any witness intimidation. How dare you?
Do you think he cares about that? Do you think he cares?
I feel like he should.
Do you think he cares? He said it before the trial. Okay. He tried to suggest it during the trial. He said it about me. Okay. That I was helping a witness intimidator by passing information to a murderer and a witness intimidator. He doesn't care. Okay. He's not going to retract anything. So forget it. It is what it is. He's disgraced himself in that statement. Okay. He's disgraced the Norfolk DA's office in that statement. and he's been patently unfair and inappropriate to Karen Reed in that statement. But it is what it is. That's what he chose to do. That's the statement he made. That's how he wants to be. That's how he wants to be remembered. That's on him.
And history will remember that, in my humble opinion. Well, yeah, it was gross, and I'm very disgusted by it all. Then today we got a incredible statement, as you mentioned, from the one and only Alan Jackson. I will read it because it's not too long. Alan Jackson's full statement. The jury has spoken, but special. This was in response. Like, this is the part that's in rebuttal to, I guess, attorney Brennan says the jury has spoken, but special prosecutor Hank Brennan, in an egregious breach of prosecutorial ethics, has tried to publicly shame and discredit that very jury. For him to attempt to supplant, is that right? Supplant.
I'm not looking at it, but it would be supplant. Yeah.
Okay. His personal views for that of the jury is a desperate attempt to save face in the wake of a unanimous rejection of the prosecution's case. The rules of professional conduct are clear. A prosecutor should support the legitimacy of the justice system and promote public confidence in its operations. Openly attacking a jury's verdict because he disagrees with that undermines that century-old edict. Mr. Brennan claims that his investigation was, quote, thorough. If that were true, the Commonwealth would have uncovered that what we, the defense, uncovered: hidden exculpatory evidence, lies and perjury by the Commonwealth's own witnesses, cops covering for other cops, a biased and corrupt lead investigator with a personal ties to the witnesses, and inculpatory and suspicious conduct by a myriad of witnesses. The only job of an ethical prosecutor is to seek the truth in a just and fair manner. The Commonwealth fell wildly short of that responsibility. Theirs was not an effort to find justice for John O'Keefe. Rather, it was a personal vendetta against Karen Reed by DA Michael Morrissey and his hand-picked prosecutors, and the people of Norfolk County millions. The fact is, Karen Reed is factually innocent, and this case never should have gone to trial in the first place. This case is a stark reminder that there has been complete breakdown in what is supposed to be our justice system. Those in power are more interested in protecting themselves than the citizens that they are sworn to protect. The Commonwealth's defamatory public comments ring hollow to the very constituents that they are supposed to serve. It is now crystal clear that that disgraced DA Michael Morrissey has no interest in actually seeking justice for John O'Keefe by identifying and prosecuting the real killer or killers. The Commonwealth would rather simply condemn the jury and its fair and lawful verdict. We are thankful for the jury's commitment to the truth and that they found their way to a just verdict. But make no mistake, if DA Michael Morrissey had his way, the truth never would have come out in this case. It would have been lost somewhere in private and deleted conversations that would have never seen the light of day. Corruption like this doesn't happen in isolation. How many innocent people have been railroaded because of failures in our judicial system? We as citizens must demand more of our institutions.
Well, I agree with all of it.
All of it.
I've said bits and pieces
Powerful.
over the course of
this
whole fiasco. And to me, this is why I like Alan so much and relate to his line of thinking and share. I've probably said this to you before too, being wired the same way. I mean, I agree with all of that. And then, you go back and you say, so he was a prosecutor, as you know, at a high level DA's office in LA, right? Which of course I'll always say it's not Manhattan, but it's close. Just a little jab there, but you get the point.
Yep.
And for many, many years, and you listen to the statement that he made today, and who sounds like the professional, ethical prosecutor background with integrity?
Our defense. Yeah.
Or Hank Brennan. Look at the difference in the way they talk about it. I think that statement he made was entirely fair, on point, and probably bottled up for a long time.
Yeah. But what a class act again. And another, although, yes, there are poignant points made throughout that statement, still remaining a class act and still being able to articulate that in a just an absolute professional, fuck off kind of way.
Well, that's his skill. I mean,
Yeah.
he's the best at this. And,
No, I've like a couple Bederow letters, a little bit. Just saying.
I mean, no, he's like, that's why he's at a top level of this profession and has the respect of, people at that level who look at him as, in our profession, as that's what it means to be a passionate, zealous advocate for someone who you believe is innocent. And so lawyers like me just love it. I mean, I love the way he tries the case. I love the passion. I love the dedication. I love the skill. I love the oratory skills. I mean, he's the best.
Yeah. And that was very not surprising to me at all, but so wonderful to hear from multiple jurors about that Alan Jackson just his presence in that room. And loveys, if you haven't heard it, babes, I was IRL, okay, and heard Alan Jackson do cross of O'Hara. And that was a weird cross too, because he was like very evasive and he was fidgety and he was odd. Oh, not O'Hara. Who was it? Gallagher, rather. Sorry, pardon me. Gallagher was a weird cross. And his ability when he's even walking and his tone changes and then him coming over, increasing his tone, his eye contact, where he's looking, how his body takes up space. It's all like it is all in like, I don't even know. It's like a symphony in my eyes.
How experienced and skilled trial lawyers do it. There are moments that you signify to the jury, I'm changing tone because this is particularly important, or I agree or don't agree with this. I want you to pay attention to this. That's all part of the litigator's skill. And, he's a master at that.
Yeah, he really is. And there is so many, like, and listen, we know that attorney David Yannetti is,
of course,
my guy. But I love how he argues as well. But for me, I always will say, and that one of the jurors in an interview also said that attorney Robert Alessi was incredible for them, and that they learned so much from him in his direct and cross examination. Oh, not well, no, did he do direct? Yeah, he did. But like he has such a different style, but it's so impressive as well. And those are the things that I always just look at, and I'm so thankful that I had the opportunity to witness this. Just watching it on the television, giving people and a whole group of individuals may be inspired to, pursue either maybe become, I don't know, a paralegal or an attorney, whatever it is you want, because you've seen the best in play.
No, these guys, look, they're the whole, and we said, I'm sure we talked about this previously too. One of the reasons why they were always destined to win was the legal team for Karen was so superior to the prosecution. And it's not 1 against 1.
Right.
It's 4 against 1, and it's smothering because they're all so good at certain things. And I mean, look, one of the best compliments I guess you could pay to a criminal defense attorney is to say, as a criminal defense attorney, if you are in the hypothetical situation of saying you're in a mess, not that I would expect that to happen, but you find yourself in that situation and you have to make the call. Okay. Jurisdictions aside, right? Because obviously lawyers are in different states.
Yeah.
But if I said, I need a criminal defense attorney for myself, knowing how this business works, knowing what it means. My first call would be to Alan Jackson for me.
And my first call would be to you. If I was in a jam, I would say, because I would be, yeah, it would be absolutely Mr. Bederow. I'd say, oh, speed dial. And if you've had time to reflect on this, Mr. Bederow, can you just tell me any kind of feelings that you have that are lingering, that there was another misjustice or injustice of a Sixth Amendment right of Karen Reed to her choice of counsel and not being able to have you? I feel like if you should have been there, I feel as though you are so brilliant that the only thing that would have made the Reed team better is if it was the dream team and you were the dream.
I mean, look, I hate it. I'm not going to sit here and lie to you. They asked me to join. I was happy to do it. Didn't happen, but I would have loved to have done it. Again, any real lawyer loves to work with other world-class lawyers like this. And, for the short amount of time that I, huddled up in theory, expecting to do this with them, I loved it. And it was great. Look forward to it. Had certain things that I was, prepared to do and wanted to do and would have been assigned to do. Out of respect for them, I'm not going to talk about that because it's their place to talk about, those kinds of things, not mine. But yeah, I mean, I think anyone who does this at a high level, when, you get tapped for duty in a case like this, of course.
Yeah. And just loveys, I see that you're writing in the chat. Melanie is on at 7:30 p.m. It is 7:01 now. That's why we have this was our pregame to the interview that I am looking forward the most of. Is attorney David Yannetti and attorney Robert Alessi are going on her show at 7:30. Now, they did Runkle on the last week, I think last Friday. And then last night they did Lawyer with Peter. But this is like our attorney, right? Like Melanie is our attorney and she's our champion. So it's so exciting and I am thrilled. Also, slight breaking news, babes. Now, I don't have an exact date, okay? But I got another message. And if you guys weren't here on Friday, I got an tweet from attorney David Yannetti, my bowl of spaghetti. Okay. And he said, you're no longer a non-consensual intern, Nurse Kim. That's what he said. He said, I don't agree with the qualifier of non-consensual. So I think we are the teammates. And allegedly next week, I don't have an exact date, but I may be having an interview with attorney Yannetti and Alessi as well. So I might have to kibby over, and Mr. Bederow will have to be the one who carries us on and brings us to life. But
no, definitely not.
It all could. It's all happening. I can't handle it. I can't. I'm gonna need 5 to 7 minutes.
I'm just a guest. I'm never the host. No interest in what you do.
Well, you're my dream. Okay, you're my dream co-host. So you have to help me out if I need you.
I'm not interviewing lawyers. No.
I'll interview you all, but I just need you as my emotional support attorney because I feel comfy when you're there, and I won't feel comfortable if I'm so nervous my pits are sweating.
I'd be happy to do that, but you clear that with your distinguished guests first.
Yes, sir. So before we go, though, at 7:03, we got another about 25 minutes to just shoot the shiznit. Barrows, tell me everything.
So this is a real thing. This is really deeply disturbing, and you have to understand how this works. It's been the law of the land since 1963. And, you hear the word Brady. It's not Tom Brady, people. It's Brady versus Maryland from the Supreme Court. That due process requires that the prosecution inform the defense of any exculpatory evidence that is in their possession, custody, or control, and which the defense may not be aware or doesn't have access to. It's just a fundamental fairness thing. And the prosecution is obligated to do that, even if they disagree with how important it is, if they think it's stupid, if it's on its face exculpatory,
Mm-hmm.
they're obligated to turn it over, because the defense gets to decide what to do with exculpatory evidence, whether it has any credibility, meaning, or value, right?
Yes.
So it's very straightforward, and the law is very clear what the consequences are. If there is evidence that is favorable to the defense, there's really three prongs to this, as they say. It has to be favorable or helpful to the defense. It would be a Brady violation if it's withheld or suppressed, not disclosed, and if it's what the law calls material, meaning it could impact the outcome if the jury was aware of it, but they were not informed of it because the defense didn't know. Okay? So you get to this case, whatever,
Mm-hmm.
and what's the biggest issue, probably bar none in this case, which is how the hell did the taillight end up looking like that?
Yes.
I mean, if you broke down the whole case to one litmus test issue about anything, it would be if the taillight shattered and there was no logical or reasonable basis to believe it happened in any other way from just a car accident, and there was no planting of evidence, then she's probably guilty. I mean, it'd be tough to find anything else. But if there was any reasonable view of the evidence that the taillight was shattered in some other way, not from a collision, if it had been planted, most sensible people, maybe not in the attic or the couch in Indiana, but most sensible people would determine that that's probably reasonable doubt, barring anything else. So that's the one issue in the case, which is the most important thing. So fast forward to sometime before the first trial, and what happened from the trials, and then what happened with BARROS's interview last night, right? So BARROS's interview last night, first and foremost, is so telling that he did it. Okay? The fact that the Dighton Police Department would even allow him to do it is so telling that they are 1,000% in the camp that Karen Reed is innocent. Okay? There isn't a sane police department in the world that would let an active duty sergeant go on social media, conduct an interview, and basically torch the Norfolk DA and what they did. That is unheard of. I've never seen anything like it. I've never heard of it, and probably will never see it again. That's, without more, that's incredible. Okay?
Yeah.
He comes in and he says last night very clearly that I met with people in the prosecutor's office. I don't think he used their names, but let's assume it's based on prior history. Lally Tully would be my guess.
Yep.
Certainly Lally. And he says there was a discussion about the condition of the taillight. And he told them it's not blown out. It's a crack. And he said they kind of were implying they wanted me to say more. And I didn't. And I told them what it was. And they wanted to show me a picture, the famous picture of what Proctor and Buchanan have testified under oath at two trials. Well, not Proctor, Buchanan at 2, Proctor at 1.
Yeah.
Was the actual condition of the taillight as we first observed it, as well as Jen McCabe and Kerry Roberts, by the way. But that's a story for another day. And he said no. And then he indicated that they were going to show me a photo, but after I told them no, they didn't. They didn't show me the photo because they knew what I would say. And that's the end of essentially that story. Okay. Now, before you get to what happened in court, Brady does not allow conscious avoidance, willful ignorance. And the problem here is you have a two-pronged Brady violation.
Oh, two-prong. Okay.
By the DA. Okay. Once BARROS tells them the taillight does not look like what you're claiming it does, that's exculpatory. That blows up the whole theory of their case. And they were obligated at that point to tell the defense there is a police officer who was contacted by the state police who was there that day and will say, it's not what we say. It doesn't matter if Lally agrees with it or not. He was obligated to disclose that. Okay. Then what he does, assuming it's Lally, he decides not to show him the photograph because he's afraid I'm going to get a negative ID. I'm going to get, you want to talk about Brady? It's bad enough he says it wasn't blown out. He's afraid he's going to say that photo is not what it looked like. And then he's going to have to disclose that. And that's a hell of a lot worse. So that's conscious avoidance. They didn't show him the photo to avoid that statement by BARROS, right? It doesn't look like that. And what's scary about it is these people are not ethical. They're not interested in the truth. They're interested in getting Karen Reed, interested in winning, or to put it in other terms, they're interested in every single thing Alan Jackson said in his statement today.
Yeah.
Because any prosecutor who is ethical, has integrity, is honest, and wants to know what happened, when they're talking to BARROS, would say, tell me about the taillight. And if they're getting an answer they don't like, but they're interested in the truth, they're going to say, this is what I would have done when I was a prosecutor. This is what Alan Jackson would have done when he was a prosecutor. This is what David Yannetti would have done when he was a prosecutor. It's what any respectable, ethical prosecutor interested in the truth would have done. They would have shown him the picture. And if the guy said no, they would have told the defense, even if they still believe he was wrong. Okay. So he didn't do that. So presumably there's no disclosure to the defense. Now you go to trial, the first trial, right? Don't ask me to say trial 1.0. I'll throw
I
up.
would never. I stopped after you didn't like it.
Oh.
Retrial and the first trial.
So
yeah.
They go to the first trial and they call BARROS as a witness. And he says, you know, what he says at the second trial. It was kind of a crack or whatever. Now, if you're the defense and you're hearing that, okay, that sounds inconsistent with what the state police are saying, but you don't know.
Yes.
You don't know, and you're not going to gamble by, you know, Dirty Harry style. Do I feel lucky today? You know,
it's too much on the line. Yes.
Too much, because if you're wrong and you show him the picture, you're cooked.
And he says, yes, this is exactly it.
So let's stay on the direct examination.
Yep.
So BARROS says there's a crack. Lally never gets him to describe the crack or compare it to what Proctor and all them say. And then what he doesn't do is show him the photo. And the reason Lally doesn't show him the photo is because he does know what BARROS is going to say. And what BARROS would have said at the first trial is, oh no, that ain't it.
Absolutely not. Yeah.
So he doesn't. He leaves it alone. Fine. What does defense do? I'll tell you exactly what they do. And at the time, they made the right decision.
Of course.
You sit there as the defense attorney, you say, well, the guy said there was a crack in it.
But not completely broken. Yep.
But it doesn't sound like what Proctor's saying.
Yes.
In other words, it's not bad. It's not perfect, but that's kind of good for us. Why am I going to cross-examine this guy and run the risk of confronting him and having him say, well, actually, sir, it was much worse. Yeah, it looked like that photo. And the reason they wouldn't do that is because they don't know, because Lally never told them. If he told them, they would have done it. If they knew, they would have shown him the photo. Right?
And that could have changed the trajectory of the outcome of trial one.
Entirely, because if you believe BARROS,
which we do,
both in terms of his credibility and the accuracy of his testimony, then that is almost per se proof that Karen Reed was framed, because that could not be. Look at the condition of the taillight.
Yeah.
Okay. This is hours after the alleged accident.
Correct.
The taillight pieces that Proctor and Buchanan are going to say reveal themselves, and Berkowitz over the course of 2 weeks, they're on the car after the accident. So that would have entirely changed the first trial. So this is, if BARROS is telling the truth last night, okay,
which of course, yeah, well, yeah,
is an egregious Brady violation. And the point is, all he's doing is confirming what common sense already tells you. Lally not showing him the photograph at the first trial and the defense not cross-examining him at the first trial tells you all you need to know. Lally knows, they don't. It couldn't be any more obvious. I'm sure I said this to you weeks ago, that this was scandalous and wrong. And now you have the evidence of BARROS, in essence, if you believe him, confirming it. So then what happens after the first trial? BARROS is never asked about it. He doesn't volunteer it. He has no Brady obligation. He doesn't know. He's a police officer. That's Lally's responsibility at the first trial.
Of course.
After the first trial, BARROS sees the press like everyone else and realizes the condition of the taillight, it's the whole case. Really.
Blown out.
And so what happens after the first trial, and enter your friend Hank Brennan? BARROS, who's a witness for the prosecution at the first trial, is never contacted by Brennan. And he guesses why. I can think of one.
Oh.
You know, he's going to hurt us.
Yeah.
So what does BARROS do? An active duty police officer who naturally should be aligned, has no skin in the game, but to this, you know, the last thing any active duty cop wants to do in a murder case of a police officer is align himself with the defense. And you know what he does? He aligns himself with the defense.
Yeah.
He goes out of his way. He reaches out to them. He lets them know this is a man who wants to get something off his chest because he feels bad. He feels like
the right thing to do, Mr. Bederow.
It's the right thing to do. And at the second trial, he does it. So the bottom line point, you know, 15 minutes later is this would appear to be a horrific Brady violation by the DA before the first trial. Something that, if known to the defense at the time of the motion to dismiss, would have been another part of that motion to dismiss.
Oh.
And then you have to understand, when you argue about a Brady violation, if there are more than one, like the Sally Port video.
Yes.
Every Brady violation, if you find that there's more than one, the materiality, does it matter on the outcome of the trial, is considered cumulatively, not in isolation. Mm-hmm. So now you have a situation where a judge would have to say, if the jury had known the truth about BARROS and the taillight, what he would have said. If they would have known the truth about the video, the suppressed video, could the combined impact of that influence the outcome of the trial? Yes. And the answer is 1,000% absolutely, and should have resulted in a dismissal. These people in the Norfolk DA's office, if this is true, they're not honest. They have no training about Brady. They don't care about Brady. And if Lally did not show him the photograph, it's on purpose. That is a conscious choice to try to avoid further disclosure by being willfully blind, consciously avoiding, I don't want to know because I know what he's going to say and I don't want to have to tell them.
Is there any repercussions that are, what will the defense do now?
Well,
or what could they do?
As it relates to a criminal case, nothing. As it relates to a potential 1983 federal civil rights lawsuit, could mean a lot.
Oh.
It's complicated, and we don't have enough time to get into the full weeds of this. Prosecutors have a lot of immunity in these lawsuits. Cops don't. It depends on whether it's a prosecutorial or investigative thing. That's a whole nother conversation for a whole nother day. But the point is this: if you file a 1983 claim under a theory that law enforcement violated Karen's civil rights by planting evidence and framing evidence, testimony from BARROS about what Lally did and what it proves, that Proctor and Buchanan probably lied, may very well have planted taillight, or at least coordinated planting of taillight. That could be a very big issue in a federal civil rights case. And in the event that if the feds wanted to reopen a criminal investigation, I'm not suggesting they will. Don't give, I have no idea. But if they wanted to investigate whether Proctor, Buchanan, or anyone else planted evidence, which would be a violation of Karen Reed's 4th, 5th, and probably 6th Amendment rights, that those would be federal crimes. What BARROS said last night and what happened, how he was examined at the first trial and the second trial, would be very powerful evidence in furtherance of a federal criminal case under 18 USC 242 of any corrupt cop, and in any federal civil rights claim under 42 USC 1983. So it's a big, big deal. And, a lot of people don't want to hear that. I know the anonymous lawyer doesn't want to hear this, but, these people need to pull their heads out of their asses. This is a big deal. And you can't just say, well, he was discredited at trial. He clearly made a mistake about the photograph at the trial. There's no way around that. But
he said last night too, Mr. Bederow, that he was prepped by the Commonwealth and was never prepped by the defense.
Right. He made a mistake.
Literally was saying, yeah, you want to talk all this shit. He didn't have an office in Boston. Of course, I went to where they're the area in which they had a spot to meet me. I didn't find it weird at all. But this is an active duty, a good police officer, a police officer like Officer John O'Keefe that we fight for, that we want to have in our corners, that is not, trying to do anything except his job.
Nicholas BARROS is any corrupt cop.
Worst nightmare.
Massachusetts State Police. To the extent you can get around the absolute immunity for the prosecutors, okay? He is their worst freaking nightmare in a 1983 claim in a potential federal criminal case under 242, because if he's credible, they planted evidence. It's that simple, okay? If he's right about the taillight, then the state police guys are lying about the taillight, and it didn't get there naturally. It's that simple. Now, you can rationalize and say, well, he must be mistaken, and that's a fair argument, whatever. But if he's credible and you like it and you have all this other evidence to go around that he supports, they have a problem. And the biggest problem they have with him is the way he was examined at the first trial, okay? That is very, very incriminating for Lally and people in the state police by not attempting to show him the picture at the trial. Think about it. It makes no sense. If BARROS is a disinterested cop, no skin in the game.
Didn't even talk to them when they were there. He was just like, I'm here for courtesy.
If you could have established through him, just a credible, good guy cop, that the taillight looked like that photo, then Karen Reed's in prison today.
Literally.
Or gonna be in jail at least, but going to prison. That's right. That's right. And the DA never asked him because they knew. And the defense never asked him.
Oh my God.
Because
Mr. Bederow, he said that he saw the picture because he saw it with Adam Lally on the trial. No, when we're going back, I'm just having I'm having a flashback. I'm having an elephant nurse Kim brain moment. When he was on the stand, when they were asked, were you shown this picture before Hank Brennan said that, and then he went back and said, no, you didn't. You had never shown this photo. But he wasn't asked the question, did you see it when you were prepped? I am clenching so hard.
All you needed to know, even if he never gives this interview last night, and this is why I talked about this previously.
I need an interview with him. I'm going to call Lindsay and see if she can give me his number.
There is never an explanation that you will ever get from anybody who understands how this works as to why Lally would not show him a photograph on the stand, which could,
my Lord.
But worse than that the defense said, we're not even going to attempt to touch this guy on cross because we don't know. Okay. There is no other reason other than Lally knew, the defense didn't. That is a Brady violation that should have been resulted in the end of this case at a motion to dismiss level after this trial. It ought to help her in her 1983 claim and could potentially help her if there were, I have no idea, any federal criminal case that ever comes to this, which, as we're told right now, there's no investigation. So I have no knowledge or opinion about that, but that would be problematic evidence.
I'd like to say, bang, bang on that note, because this is huge. And what happens and where the defense team goes with this and what additional information is obtained, I'm following it. And if there is a 1983 case, okay, I am going to join as a as a consensual intern, potentially, because I need to know all of it.
This is one of the things that was so frustrating at the time.
Yeah.
Okay. Now, during the motion to dismiss, people like me were saying, how do they not get an evidentiary hearing? Why is Adam Lally not a witness? Now, imagine if Lally had to be a witness about the Sallyport video, which is bad enough. Okay. But imagine if the defense had learned about the BARROS fiasco and Lally had to testify pre-trial too on a hearing about this and be subjected to being cross-examined about what the hell happened, why you didn't show him this photo, what did he tell you, what did you know, why didn't you tell the defense? This case would have been over at the pre-trial stage because there's no good answer for this.
And the damages that have, the Commonwealth, think of all, not only the pain and suffering of both families, but now we have, the cost to the Commonwealth, the cost to Karen Reed, her triple damages. I'm not saying monetarily, but I'm just saying this is why we have rules and law. We're law and order. And this is what everything was put into place to have guardrails so that instances like this don't happen.
The good news is this, and I know we're down to
we're down to the wire.
Here's the beauty of if they do bring a 1983 action, okay? Federal civil discovery is a bitch. All right. And depositions in a federal 1983 claim, they can be very uncomfortable. They are video recorded often. And you can be damn sure that if they bring a case like this, Lally, come on down. You're next on The Price is Right. You will be deposed. Tully, you will be deposed. BARROS, not aggressively, you will be deposed. This will all come to the forefront and come out for all to see. Michael Morrissey, what did you know? All of this will happen in a federal lawsuit if they choose to bring one.
Wow. And on that note, Mr. Bederow, thank you so much, as always, for coming over to my house to talk all the shit with your emotional support nurse, as you are my emotional support attorney. And no one I would have rather spent my Tuesday leading up to the interview with attorney Melanie Little is having with the defense team and Mr. Yannetti and Mr. Alessi tonight, which is in 1 minute. Do you have anything else that you would like to say to the loveys before you leave? Anyone to say goodnight to?
good night to everyone, but go over and support Melanie. She's great. She's been doing
She's
this
the
forever.
best.
This is a perfect interview for her, so go watch.
And she is going to be, I'm so proud that she is the one who gets to kick everything off. And let's have a great night. And thank you, as always, for your time. I appreciate you, my Mr. Bederow. Good night.
Good night.
Bye, loveys.
Bye.